we will go ahead and bring everyone back. And what I'm going to do is ask for a roll call vote just to reestablish quorum here.
Sure. Kasuga?
Here.
Fu?
Here.
Harb Sheets?
Here.
Nystrom?
Here.
Phillips?
Here.
Riscate?
Here.
Rogers?
Here.
Tate?
Here.
Roll's complete.
Thank you so much, Ms. Porto. Quorum having been reestablished, we will turn to item number 14 as it relates to ASPBB, the Association of State and Provincial Psychology Boards.
Mr. Fu?
Oh, yes.
We did have a brief update on 13B and C.
Oh, my apologies, Dr. Phillips. Didn't mean to move on from the remainder items for item 13. I will turn it back to you for items B and C of 13.
And I will turn it over to Ms. Monterrubio.
I am here if you could just give me 1 second.
Sure. It's page 41 in the combined packet.
Thank you. And can everyone hear me?
Yes.
Okay, perfect. So the Enforcement Committee and board staff began a comprehensive review of all enforcement-related sections of the California Code of Regulations and the Business and Professions Code. The committee and staff have completed their review of the regulatory sections and will continue working on the review of the statutory sections at the next Enforcement Committee meeting. So there's no action requested at this time. This is informational purpose only.
Thank you, Ms. Monterrubio. Did any board members have any questions about that portion of the report? Or the Enforcement Committee report? Perhaps we should open it for public comment. I don't know that there's going to be any, but in all fairness.
This is the moderator. I've opened up the Q&A. Members of the public, if you would like to participate, click on the Q&A icon located at the bottom right corner of your WebEx screen and type, "I would like to make a comment," and send it to all panelists. The instructions are on the screen for your reference. Board President, no requests have been submitted. Would you like me to close the Q&A feature?
I'm not the board president, I sure would.
Good, thank you.
Thank you very much. And that concludes the Enforcement Committee report.
Thank you, Dr. Phillips. We'll now turn to item 14 as it relates to the Association of State and Provincial Psychology Boards. The board had an opportunity to attend their mid-year meeting, and because it was held virtually, so we were able to participate through their webinars in progress. The hand carry is available for the full report on what was discussed, but I wanted an opportunity to invite board members to share their reflections and any observations or insights as it relates to the mid-year meeting, which covered a range of issues, including the state of ASPBB itself, as well as the EPPP Part 2 exams and where jurisdictions nationwide are going. So with that, I do see a hand from Dr. Phillips, so we'll turn it over to Dr. Phillips.
Of course, it's me again. I just wanted to mention, I think the primary issue that was on my mind when I was finished participating in the meeting, and shout out to Dr. Rogers for a wonderful mindfulness exercise during the course of the day. The thing that struck me, I think, was, and it was an issue acknowledged by ASPPB, and it's one I think is coming more to the fore and is of concern to some of the member boards, is exactly who is ASPPB? Is ASPPB the organization that represents and does work on behalf of all the psychology boards, or is ASPPB an entity which has its own agenda? And I know that ASPPB has an intention to have town hall meetings in the upcoming months to try to ventilate some of these issues, and hopefully one of the town hall meetings will be focused on that issue. But sometimes it feels like ASPPB is at odds with perhaps the interests of the boards and the interests of its licensees. So hopefully we'll get greater clarity on that one as time goes by. So that was the thing I think was the biggest takeaway for me. Thanks.
Hi, it's Dr. Tate. So that was my very first meeting of ASPPB. I wish it was in person, but I was happy to participate. It was amazing to hear from other jurisdictions. And I have to say, and I'm a little biased, that California, we are ahead of the curve in many areas. In many of the breakout sessions, I heard complaints from other jurisdictions about things that we have already implemented. So I was very proud to be representing California, and I hope to attend more meetings in the future.
This is Dr. Harpsheets, and I have previously attended their meetings. My sense is that the states are sort of, in many ways, very different from each other, and I don't get a sense of cohesiveness or that ASPPB was really looking at, well, gosh, what are other people doing, and how, if we come up with this proposed policy, how is that going to fit with other states' situations, guidelines, and particularly because it does take us quite a long time to make changes. So, for example, I was very surprised to learn how many states require graduation from an APA accredited program. And that's something ASPPB is considering making a requirement at this point, and that's not true for California. So it concerns me that there isn't some coordination of effort to include the needs and situations of the various states. And we are a big state and have a lot of licensees. And so I wish there was more attention paid to kind of where we're coming from, what our needs are, before we hear this sort of, well, we're thinking of doing this, and it feels sometimes almost like a mandate.
This is Dr. Kasugan. I would like to piggyback on what Dr. Harpsheet said, because I also have the same concerns with regards infringing on some of our jurisdictional power when it comes to things like, of course, it's important for us to be portable, but then that's when there are things that are at odds with what we are doing here in California, it puts us in a very difficult position. So yeah, I think that I wish that there's some proportionality when it comes to the number of licensees and the kind of the size of some of the boards that are there. For instance, California is really a large board, and we have a lot of licensees that are going to be affected. But I feel like our voice isn't necessarily as large. And that's a little concerning for me. I think I'm sure that the smaller jurisdictions are probably happy that there's equal weight for big and small jurisdictions, but I'm just concerned that what Dr. Harpsheet has mentioned, that there are times when things are not when there's a conflict between what ASPPB is doing, is where it's heading, and where California is heading.
Thank you so much for everyone's input. Oh, Dr. Rogers, please.
Yes, hi. I would like to just echo what my colleagues have already said here on the call about ASPPB. Um, I was fortunate enough to be able to lead a mindfulness practice, which I really enjoyed. I also really enjoyed the smaller breakout groups where we were able to sit and talk with other people from other jurisdictions and other boards. So that was a learning experience for me. The other thing that I just wanted to mention was that there was a call for volunteers to join ASPPB in some capacity, whether it's on a task force or on a committee. And so that might be an opportunity for board members to join one of those to offer our unique perspectives on what has been working in the state of California and might give us more voice in ASPPB moving forward. So I just wanted to share that as well. Thank you so much.
Thank you, Dr. Rogers. And again, our thanks to you for representing the state of California so well in leading many of the practices, the mindfulness practices at the mid-year meeting. So thank you for that, for your leadership on that effort. Dr. Phillips?
I also wanted to mention, and I don't want to defend ASPPB because I do think sometimes that policies are implemented that don't give consideration to all the jurisdictions. But I also have to say that part of the problem we've had in terms of our participation with ASPPB, and I do thank Dr. Rogers for her suggestion, that would be one way to try to address this, is that typically because of restrictions on travel imposed in the state government, we've been unable to actually be in attendance at meetings unless we had people who are participating as a result of their being picked as a panelist. So we've had trouble getting authorization to go to ASPPB's yearly meeting and their mid-year meeting. So to some extent, I don't want to shift all the burden to them. We also have been hampered in our efforts to have our voices heard, but certainly suggestions like that made by Dr. Rogers is one way for us to have perhaps a greater voice in the organization. So we'll have to see how things go as things move forward, but it's always interesting to find out what other jurisdictions are doing. It also makes you conscious of the fact that California and California state government in general is a much more complex and substantial thing than many of the jurisdictions where they might have 50, 100, 200, 400 licensees, and they perhaps have a part-time employee working for the board as opposed to, an excellent staff like we have. So, so there are different considerations at play, but it is always interesting to see the cultural differences, right down to how board members are suggested or are selected in some jurisdictions, which tends to be a reliance sometimes on professional associations to pick the board members, as opposed to California's process, which is largely independent of the psychological of the different psychological associations. So it is always kind of eye-opening to be involved, and I think it's good for us to have an opportunity to reflect on what we're doing and also to hear what other people are doing.
Thank you, Dr. Phillips. I'm going to go to Dr. Rogers and then to Ms. Sorick.
Oh, excuse me. Yes, I just wanted to say thank you to Dr. Phillips for the information about authorization to travel. I was not aware of that, so I just appreciate that additional clarification. Thank you.
Thank you, Dr. Rogers. Ms. Sorick, then Dr. Kasuga.
I just wanted to briefly mention that the annual meeting, which will be held in, I believe in the fall, I'm not exactly sure the date, but it will be another virtual offering. So my hope is that we can request for all board members that are available to attend to be able to attend, and then to also send a handful of staff members if possible. I think it's helpful when travel restrictions are a barrier, that if there are virtual offerings, that we have an opportunity to participate and have a seat at the table, so to speak. So I just wanted to mention that the annual meeting will be another virtual offering.
Thank you, Ms. Sorick. Dr. Kasuga?
Yes, I appreciate what Dr. Rogers mentioned with regards calling for volunteers. And I just wanted to add as well that some of the volunteer positions where we can have an influence doesn't really require a lot of travel. It just requires meeting up virtually throughout the year. So that can be an avenue that we can all explore if we want to have more voice in the organization. So I appreciate both Dr. Rogers and Dr. Phillips for their input with regards the importance of having California have more of a voice within ASPPB.
I love the volunteer core that we are developing over the course of this discussion, and just really thrilled that there's so much interest for further engagement on this front. Before turning to public comment, I will say one thing, which is these are all discussions that ASPPB had. The Board of Psychology itself does not have any pending changes relative to what was discussed at ASPPB, what was presented by ASPPB at that point. So you've heard comments more broadly about some of the different considerations with relation to APA and some of the other discussions here, and I want to make sure that we convey that the board at this point doesn't have any items agendizing any of those changes. And of course, if we did, we would do so in a collaborative manner that includes our stakeholders broadly, many of whom who are attending today. So with that, I'm going to turn it over to Madam Moderator to go ahead and open it for public comment.
This is the moderator. I have opened up the Q&A. Members of the public, if you would like to participate, click on the Q&A icon at the bottom right corner of your WebEx screen and type, "I would like to make a comment," and send it to all panelists. The instructions are on the screen for your reference. Board President, no requests have been submitted. Would you like me to close the Q&A feature?
Please do. Thank you so much for that. So with seeing no, oh, sorry, go ahead, Dr. Kasuga. Never mind. Okay, so seeing no further hands or mics unmuted, we will go ahead and move on to item number 15. So I'm going to turn this over to Dr. Phillips, who is standing in today for our Legislative and Regulatory Affairs Chair. So Dr. Phillips, back to you.
Okay. So we should be able to go through this in relatively short order. I did want to mention to people, when we get down to the review of the watch bills, there are a few watch bills that we're going to pull out for discussion. But if there's a particular watch bill that you're concerned about, other than number 5, number 11, or number 14, please keep that in mind when we get to that point, so you can let me know which ones you'd like us to pull out for further discussion. Because for many of these, the watch bills, the status has not changed. But let's go back to item 15A, board-sponsored legislation for the 2021 legislative session. Item number 1 is SB 401 PAN, the unprofessional conduct related to sexual acts and behavior. Ms. Rivera, if you could briefly take us through the status on SB 401.
Absolutely. Good afternoon. So 401 is currently, it passed out of the Senate, and it is over in the Assembly, and they're waiting to take it up in Business and Professions. We don't know at what point that is going to happen, but it has made it out of the Senate.
Great. I did want to give a shout out to the California Psychological Association for working with us on this bill. in terms of finding something that would work both from the point of view of the board and from the point of view of licensees. It was a very helpful process, and in particular, Dr. Winkleman gave us some great input. So I guess that proceeds apace. I guess we'll open for public comment on PAN.
This is the moderator. I've opened up the Q&A feature. Members of the public, if you would like to participate, click that Q&A icon and type "I would like to make a comment" and send it to all panelists. No requests have been submitted. Would you like me to close the Q&A feature?
Please.
Thank you.
Okay, and next up is item 15A2, Pathways to Licensure Statutory Revisions. Again, Ms. Rivera.
As it pertains to pathways, which is the next item, and the sunset provisions, we have been notified that it is going to be, they are going to be made in SB 801. We are currently awaiting amendments that would include us in there, but that bill did pass out of committee yesterday. So we are in a holding pattern and waiting to be notified that we have been included.
And if I understand correctly, at this point, only the Board of Behavioral Science of, at least in our neighborhood, has in the bill. Yeah.
Yes, that is correct.
So we're kind of in a wait and see posture.
Yes.
Okay. I'm gonna, before I open for public comment, maybe we'll go to item number 3, and then we can open 2 and 3 to public comment.
Okay.
So if you can go on to 3.
Number 3 is the, let's see, let me get there, hold on. Requested legislative changes regarding Business and Professions Code 2912 and addition of sections related to reinstatement to active after voluntary surrender. Licensure committee delegated authority and authority to issue waivers were provided to the Senate and Assembly Business and Professions committees, along with the board sunset report and COVID supplemental. This is for informational purposes only. No action is required at this time.
And if we were to see those, would they show up in SB 801?
I believe so. Ms. Sorick, can you speak to that?
Yes, we heard from Ms. Mason, the committee consultant for the Senate Business Professions and Economic Development Committee, that the committee is currently reviewing all of the statutory submissions that were provided by the board from our background papers. And they are considering those sections for inclusion in SB 801. We have not been told which sections in particular will in fact be included in the bill. And as Ms. Rivera mentioned, the bill was heard yesterday and the board is not currently in that bill as of yet. And we are in a wait and see pattern on both agenda item 2 and 3 here.
Thank you. Is there any board comment on 15A, 2, and 3? I'm not seeing any hands going up or any mics unmuted. So why don't we open it up for public comment?
This is the moderator. I've opened up for public comment. Members of the public, you can click the Q&A icon, type "I would like to make a comment" and send it to all panelists. The instructions are on the screen for your reference. No requests have been submitted. Would you like me to close the Q&A feature?
Yes, if you would, please.
Thank you.
Next on the agenda is item 15B1, which relates to the Bagley-Keene Open Meeting Act and teleconferencing. Again, I'm going to call on your good offices, Ms. Rivera. Ms. Are you unmuted?
Sorry, one moment. I'm trying to get to that page in the packet.
It's page 56 out of 250.
Thank you. The Bagley-Keene Open Meeting Act of 1967 provides the public the ability to actively engage with its government and be a part of the decision-making process. Bagley-Keene mandates open meetings for California state agencies, boards, committees, and commissions, and facilitates transparency of government activities to protect the rights of citizens to participate in state government proceedings. Under existing law, any meeting of a state body that is an advisory board, advisory commission, advisory committee, advisory subcommittee, or similar multi-member advisory body may hold an open meeting by teleconference if the meeting complies with the requirements of the Bagley-Keene Act. Existing law requires that when a member of a multi-member state advisory body participates remotely, the body provide a means by which the public may remotely hear audio of the meeting or remotely observe the meeting. AB 885 seeks to modernize the teleconference statute of Bagley-Keene to encourage more participation and engagement in public service. This bill ensures accessibility for both the public as well as members of the state body. AB 885 maintains that public meetings remain transparent by requiring public meetings that are conducted via teleconference to be observable to the public both audibly and visually. Additionally, AB 885 clarifies that members of a state body participating remotely shall count towards a quorum and would only require public disclosure of the designated primary physical meeting location from which the public may participate. Lastly, the reform in this bill is not replacing physical meetings, but authorizing state bodies to have the ability to have a meeting via teleconference in addition to a physical meeting location. On April 29th of this year, staff learned that this will be a 2-year bill. It is currently in the Assembly Governmental Organization Committee. Staff recommends the board watch AB 885. However, staff also seeks to work with Dr. Rogers to draft a letter of concern regarding the requirement that the meeting should be both audibly and visually observable to the public. Staff's concerns are as follows. Technology may not allow for blurred backgrounds and health and safety of board members and their family. And there is considerable research regarding Zoom fatigue and the impact of virtual meetings on mental health from cameras in meetings.
Okay, great. I wanted to add one additional concern. And perhaps, Ms. Sorek, you could think about this. I don't know if you had an opportunity to or not. So what they're saying is we could have a meeting that's in part, if I understand correctly, teleconference, and in part people being in place at the meeting location, which typically be in Sacramento. That being the case, I don't know how we're going to integrate technology. Does that mean that the people that would be sitting at the board, that would be sitting at the primary meeting location, the board members of the primary meeting location, would need to be on WebEx? Or are they anticipating some kind of hybrid where you would have a videographer for the live meeting and some kind of WebEx type system for those that are not able to attend in person?
I'll defer to Ms. Rivera on that. My understanding and my concern is based on the requirement of cameras for those participating by electronic means.
Right. My concern, if I can put it in a more concrete way, that maybe you guys can think about as you're thinking about this letter, my concern is that we're going to have a videographer at one end, and people are going to be using WebEx at the other end. And this would include committee meetings, if I understand correctly. So it's going to mean having videographers much more often, which I don't know if is really within the capacity of DCA to provide us with that kind of videographic coverage. But I may be overthinking this. I'm just having a hard time conceptualizing.
No, I believe you're correct, Dr. Phillips. I believe they want to make it possible for teleconferencing to occur. However, they also want to make it mandatory that people be visible. And so that would require a videographer. But I do think it's going to be kind of a hybrid setup where at the public location, you're going to have people there, but you're also going to have some type of setup that allows for WebEx for folks who are participating remotely.
Yeah, this is Bill McGuire. I had a kind of thought on this, maybe a little bit different take. And I'm thinking that as the section is being amended, Government Code 11123, B mentions that, B1B, I should say, the portion of the teleconference meeting that is required to be open to the public shall be both audibly and visually observable to the public at the location specified in the notice of the meeting. So that means that if we have a hybrid meeting where some members are present and some members of the public come to that physical location, they would certainly be able to visually and audibly see the members who are present. And presuming we're able to teleconference in those members that are not present, we would also be able to visually and audibly see them. It doesn't state, as far as I can tell, that those members who are participating remotely need to have to see everyone else. They just have to hear. They just have to hear them like we're doing now. At least that's how I interpret it. It doesn't say anything specifically to contradict that.
Yeah, I just think it's kind of confusing.
It is. It's not clear if that's what their intention is for it to be that way. And it's also not clear. I guess it's more clear actually to me. Another item that we talked about previously was whether or not members of the public could participate remotely. And under this construction, I don't think that they can, but I don't know if that's the intention of the author or not.
So maybe it's part of our letter process, we could get some clarification as to what they're envisioning. I'm sorry, Mr. Rivera, I cut you off.
It's okay. In my conversations with the author's office, I think the overall intent is to increase participation. That includes with the public. And so I think, their goal is to add teleconferencing as a permanent way for folks to be able to participate. I think there's the issue of obviously the folks who are members or commissioners or board members needing to be on camera. And I don't think that necessarily applies to the participants, the general public. I think you're right about that. I think that's just audio. But I do think the overall intention is to increase participation. So we can definitely chat with the author's office to help them, to ask them to somewhat clarify some of the issues, concerns we have with them and see if they're receptive to it.
And that's good. I'd be happy to work with you on that. I just had one other final point, and that's in the to be amended section, again, 1123 B1C. The last sentence does kind of speak to what we were just discussing. It states, as amended, the agenda shall provide an opportunity for members of the public to address the state body via teleconference is being added directly pursuant to a section at each teleconference location. And I had previously noted that part where it says at each teleconference location probably should be changed to effectuate their purpose here, because according to their scheme, there's only going to be one physical location, but that does kind of muddy the water a little bit. So it does require some clarity. I would recommend a change, and I can send it to you separately, of changing that phrase at the last sentence from at each teleconference location to the designated primary physical meeting location. But
Mr. McGuire, could I ask you one question?
Sure. I hope I can answer it.
Yeah. Well, as you read the bill, do you think it's their intention to have this capacity for every meeting, or only meetings that are teleconferenced?
Well, specifically, this only applies if we are having a teleconference functionality. So if all board members attend physically and we don't have a teleconference function, this bill wouldn't affect that.
Okay. It does seem like a bit of a muddle, but maybe we'll get more clarity once we speak to the author's office. Are there other comments from board members on this particular item?
Yes, I have a question. This is Shakanda Rogers. Thank you, Mr. McGuire, for your points on some of these sections. I also have a question about section 2, I believe, under 11123, right under F at the very bottom of that page, where it says, for the purposes of this subdivision, teleconference means a meeting of a state body, the members of which are at different locations connected by electronic means through both audio and video. And so that's why I was raising my hand and then putting it down, because I wasn't exactly sure how to read that. So is this saying that people who are not on site, who might be at a remote location, would also need to have their video on? Am I reading that correctly? I just wanted to see if I could get some clarification on this section. Thank you.
Yes, from what I understand, each board member, commissioner, et cetera, would need to have video, even if they are participating remotely.
And I was just going to look up from another source, if you give me a moment, and if there are any further comments, I can definitely get back to you on that item.
This is Antoinette. It seems pretty clear that if the language says both audio and video, that it's not one or the other, which it looks like it originally was written to allow for either audio or audio and video. And I think even just having it amended back to maybe the original language would allow for flexibility for someone who was participating remotely, especially if there are technical issues. As you all know, board members, I don't think your Surface Pros have cameras. I know my laptop doesn't have a camera, and I had to use my son's homeschool camera to conduct interviews. There are limitations, and there are cost concerns on top of other privacy and other concerns.
So perhaps that should be brought to the author's attention as well. Is that what you're saying?
That would be my recommendation.
Yeah.
Yeah, previously the section allowed for either audio or both audio and video. So it would be deleting that either audio part and making it solely audio and video together. So that's true. I think that creates a world of logistical problems, or it may, let's say.
Hi, this is Anna. I also would want the author to maybe elaborate on what the necessity to be on video exactly is. For me, when in a meeting, for people to make sure that they participate fully, usually it's visuals of the presentation or what we're talking about, not necessarily having to see the person, just how they look when they're listening to a meeting. I don't see how that could, I don't see how that exactly benefits or enhances any experience.
I would concur, but I mean, I'm sure different people have different opinions on that. Other board comments? Now, the recommendation is that we put this on a watch status. Is that correct, Ms. Rivera?
That is correct.
Okay. That does not require a motion, if I recall correctly. But does anybody have any feeling a contrary feeling on that particular subject? Okay, not hearing any. Why don't we open this up for public comment?
This is the moderator. Members of the public, if you would like to participate, click on the Q&A icon located at the bottom right corner of your WebEx screen and type, I would like to make a comment, and send it to all panelists. Instructions are on the screen for your reference. No requests have been submitted. Would you like me to close the Q&A feature?
If you would, please, that'd be wonderful.
Thank you.
And am I correct, Mr. McGuire? We don't need a motion to put something on a watch status.
Yeah, that's correct. I was just had unmuted myself in case there were further questions, but I wanted to, hearing no public comment, I would just check with staff that it sounds like we've been coalescing around the idea of a letter and or verbal reaching out to the author's office. I just want to make sure staff is clear on which elements have been identified by the board and myself regarding those. And I'm, like I said, again, I'm happy to work with staff to kind of point out some of those items as well.
Yeah,
Yes,
I
I've
think
made
during
notes.
the discussion, there were some questions brought up by members. So I don't know if we need a motion by the board to have staff follow up with the member's office on those questions, or if we can just do that as a point of clarification.
Yes, I think the latter, as long as you're clear enough, and it is the kind of consensus of the board. It's not an official action, but if there's no opposition and folks on the board are directing staff to work on that, I think that's sufficient.
Okay, and so perhaps, Mr. McGuire, we can follow up with Mr. Rivera before reaching out to the member's office to just make sure we've captured all of the questions and concerns.
Sounds good to me.
Okay, so moving on then, I guess. We're moving on to 15C1, Aguilar Carey telehealth. Ms. Rivera?
Yes, thank you. This bill would require the State Department of Healthcare Services to indefinitely continue the telehealth flexibilities in place during the COVID-19 pandemic state of emergency. The bill would require the department by January 2022 to convene an advisory group with specified membership to provide input to the department on the development of a revised Medi-Cal telehealth policy that promotes specified principles. The bill would require the department by December 2024 to complete an evaluation to assess the benefits of telehealth and Medi-Cal, including an analysis of improved access for patients, changes in health quality outcomes and utilization, and best practices for the right mix of in-person visits and telehealth. The bill would require the department to report its findings and recommendations from the evaluation to the appropriate policy and fiscal committees of the legislature no later than July 1st, 2025. On March 19th, 2021, the Legislative and Regulatory Affairs Committee voted to recommend the board take a support position on AB 32. On April 2nd, the board adopted the Legislative and Regulatory Affairs Committee's recommendation to support AB 32. It passed out of the Assembly Appropriations Committee yesterday. Let me find my notes, on a 16-0 vote. And so it will be moving along to the floor at this point. This is for informational purposes only. No action is required at this time.
Okay. Is there any board discussion? I guess we'll open it up for public comment.
This is the moderator. I've opened up the Q&A. Members of the public, the instructions are on the screen. Click on that Q&A icon, type I would like to make a comment, and send it to our panelists. No requests have been submitted. Would you like me to close the Q&A feature?
Yes, if you would, please.
Thank you.
Okay, we're next moving on to agenda item 15C2, Salas. Ms. Rivera.
Yes, this is AB 107. This bill would expand the requirement in Business and Professions Code, section 115.6, which relates to the issuing of temporary licenses for individuals married to or in a domestic partnership or other legal union with an active duty member of the Armed Forces of the United States. The bill would exempt from these provisions a board that has a process in place by which an out-of-state licensed applicant in good standing who is married to or in a relationship or a legal union with an active duty member is able to receive expedited temporary authorization. Staff spoke with the author's office and sponsor, who advised they are willing to assist the board in making the necessary modifications to BPC 2946 to include the board under the exemption. On March 19, 2021, the Legislative and Regulatory Affairs Committee voted to recommend the board take a support if amended position on AB 107. The board voted to approve the Legislative and Regulatory Affairs Committee's recommendation to support if amended AB 107. This bill did pass out of the Appropriations Committee yesterday. It is our understanding from the author's office that they intend to include us in the amendments they will submit when the bill gets to the Senate Business and Professions Committee. So we are in a holding pattern on that. This is for informational purposes only, and no action is required at this time.
Thank you. Any board comment on this particular provision? And let's go to public comment again.
This is the moderator. The Q&A is now open. If you would like to participate, click on the Q&A icon at the bottom right corner of your WebEx screen and type, "I would like to make a comment," and send it to all panelists. No requests have been submitted. Would you like me to close the Q&A feature?
Please.
Thank you.
We'll move on to 15C3, Durazo, and again, Ms. Rivera.
Just one moment. Let's see.
It's page 106.
Got it. SB 731. Among other things, this bill amends section 11105 of the Penal Code, which would prohibit the board from receiving conviction information for applicants to the board if their conviction was granted relief pursuant to sections 1203.4, 1203.4a, 1203.41, 1203.42, or 1203.49 of the Penal Code, so long as a period of 2 years has elapsed since the date the relief was granted and the applicant was not convicted of a new criminal offense. This bill would have a large impact on the Board of Psychology's licensing and enforcement programs, and it would hinder the board's ability to carry out its legislative mandate of consumer protection. Currently, the board completes an enforcement review for every applicant with a criminal history, determines whether the crimes committed are substantially related to the duties of the licensure. This bill would significantly diminish the board's ability to make these determinations without access to the necessary conviction information. On March 19th, the Legislative and Regulatory Affairs Committee agreed with the staff recommendation to oppose SB 731. On April 2nd, the board approved the Legislative and Regulatory Affairs Committee recommendation to oppose SB 731. This bill did pass out of the Senate Appropriations Committee yesterday. One moment, where am I? On a 5-2 vote. This is for informational purposes only. No action is required at this time.
So there's really been no change other than...
I do believe they accepted some amendments, but those amendments haven't been printed yet. Once those amendments are made public, I can review and let you guys know how those affect our position, but I doubt they will affect it.
Yeah. Yeah. Any board comment on this bill? Okay, public comment.
So moderator, I've opened up the Q&A. Members of the public, the instructions are on the screen. You can click the Q&A icon, type "I would like to make a comment," and send it to all panelists. No requests have been submitted. Would you like me to close the Q&A feature?
If you would, please.
Thank you.
Okay, that being the case, we'll move on to 15C4, which relates to citations of minor violations. Ms. Rivera.
SB 772. This bill would prohibit the assessment of an administrative fine for a minor violation and would specify that a violation shall be considered minor if it meets specified conditions, including that the violation did not pose a serious health or safety threat and there is no evidence that the violation was willful. On March 19th, the Legislative and Regulatory Affairs Committee voted to recommend the board take an oppose unless amended position on SB 772. On April 2nd, the board voted to adopt the oppose unless amended recommendation made by the Legislature and Regulatory Affairs Committee. Staff has learned that SB 772 will be a 2-year bill. This is for informational purposes only, and no action is required at this time.
Thank you. Any board comment? Okay, well, how about any public comment?
This is the moderator. Members of the public, if you would like to participate, click on the Q&A icon, type, I would like to make a comment, and send it to all panelists. No requests have been submitted. Would you like me to close the Q&A feature?
If you would, please.
Thank you.
Okay, we're now going to move on to the review of watch bills, agenda item number 15D. And discussions with staff, we pulled 5, 11, and 14 to discuss. Are there any other bills that people would like to have pulled up for discussion? Okay, seeing none. Let's go to item number 5, 15D5 from Lowe. The Frontline Provider Mental Health Resiliency Act. Ms. Rivera.
AB 562. This bill would require the Director of the Department of Consumer Affairs to establish a mental health resiliency program to provide mental health services to licensed healthcare providers who provide or have provided healthcare services to COVID-19 patients. The bill would require the relevant healing arts boards to notify licensees and solicit applications for access to the mental health resiliency program immediately upon the availability of services. The bill would require an applicant to make an attestation that states, among other things, that the applicant is an eligible licensee as defined. The bill would make an applicant who willfully makes a false statement in their attestation guilty of a misdemeanor. This bill would exempt the records associated with the mental health resiliency program from disclosure pursuant to the California Public Records Act. On April 2nd, the board agreed with the Legislative and Regulatory Affairs Committee recommendation to watch AB 562. In terms of the current status, let's see. It passed out of the Approps Committee yesterday on a 16-0 vote. This is for informational purposes only, and no action is required at this time.
Yeah, I had one comment on this, but I know, Mr. McGuire, you were also asked to take a look at this this bill in particular. Did you have any comments you wanted to make on this particular bill?
Maybe after you, Dr. Phillips.
Okay. My one concern here is that in reading through the bill, if I understand correctly, Ms. Rivera, it's a limited number of types of healthcare licensees that are included within the scope of this program.
I believe so, and I think they're still working on the details.
Okay. The one thing I was wondering whether our licensees shouldn't be included as well and have access to these services, given the extraordinary stress that's been created and additional workload that's been created for mental health providers. I'm not sure, though, if it's the author's intention only to really work with people who are dealing with hospitalized patients. Now, there are certainly psychologists, social workers, and other mental health professionals that work in that context, although I'm honestly not sure how much direct contact they're having with people or we're having with people that are suffering from serious illness as a result of COVID. So I'm a little directionless on this, but I just, the thing that occurred to me is whether our licensees should be included.
I can definitely make a note and reach out to them and see if that was one of their intentions.
Yeah,
get back to you.
If they're only dealing with people that are actually walking into the hospital room and we don't have feedback necessarily that those were psychologists or other mental health professionals, perhaps it's not an issue, but I'm curious.
I will look into that and get back to you.
Thank you. Mr. McGuire?
Yeah, I let you go first, Dr. Phillips, because you largely covered my comment. I was just going to point out, since there was some question raised, that yeah, this appears the benefits of this proposed program would be enjoyed so far, it seems, by licensees of the Board of Nursing, the Medical Board, osteopaths, the physician assistants, and respiratory care board. And so certainly those seem to share a common element of being hospital workers. But, there's certainly no harm in asking potentially if it could apply to us, since certainly some of our licensees have also been responsible for responding to the COVID-19 pandemic. So just pointing that out.
Okay, thank you. I appreciate that. Are there any other board comments? Okay. Why don't we open it up for public comment?
This is the moderator. I'm opening up the Q&A. Members of the public, if you would like to participate, click the Q&A icon, type "I would like to make a comment," and send it to all panelists. No requests have been submitted. Would you like me to close the Q&A feature?
If you would, please.
Thank you.
Okay, we're next moving to 15D11. And Ms. Rivera, when you're ready.
Yes, this is AB 1236 by Ting. As amended, this bill would require all boards who oversee healing arts licenses licensees to request workforce data from licensees and registrants for the purposes of a future workforce planning. It specifies that the data may be requested at the time of electronic application for a license or license renewal, or at least biennially from a scientifically selected random sample of licensees and registrants. This bill would require these boards to maintain the confidentiality of the information they receive from licensees and to only release information in aggregate form that cannot be used to identify an individual. In addition, AB 1236 directs these boards to post a specified demographic information in aggregate, which was collected on the internet website that they each maintain. Lastly, beginning July 1st, 2022, this bill could require each board or the Department of Consumer Affairs on its behalf to provide the information annually to the Office of Statewide Health Planning and Development. On March 19th, the Legislative and Regulatory Affairs Committee voted to watch AB 1236 and directed the chair of the committee and staff to have a conversation with the author's office about the data points being collected to allow a more informed discussion at the April 2021 board meeting. On April 2nd, the board agreed with the Legislative and Regulatory Affairs Committee's recommendation to watch AB 1236. On April 29th, this bill was on the Assembly's second reading file. Since the board's initial review of this bill, it has been amended to add sexual orientation and disability status as data points. It also states that a licensee or registrant shall not be required to provide any of the data outlined in the legislation. The bill is keyed fiscal, however, the exact costs are still undetermined. Staff remains concerned that the requirement that each board be required to produce reports at least biennially and post the raw data on its respective website. We have learned that they are considering amendments to make the report only due from OSHPD, not each board. So we are hopeful about that, but we do not know when, if or when those amendments will occur. Due to the requirement to produce a report at least biannually, staff recommends the board take an opposed unless amended position on AB 1236, which we have done. While staff supports the voluntary collection of information, the requirement that the board compile and submit a report of this data would be cost prohibitive to our program, which is currently in need of a fee increase. No action is needed at this time.
Would our concerns be addressed if this was going to be OSHPD's responsibility?
Yes.
And what is OSHPD?
It's the Office of Statewide Health and Planning, I believe.
Okay.
So it would put the onus on them to produce the report, not each board.
So you would like us to take an opposed unless amended position?
We have already submitted a letter.
Oh, you
to the
have?
auditor's office. Yes.
Okay.
Yes.
I appreciate the clarification.
Mm-hmm.
So no motion is necessary for purposes of this?
Correct.
Correct. Okay. Okay. Is there any board comment on 15D11? Okay. And why don't we open it up for public comment?
The Q&A now is open. Members of the public, you can click the Q&A icon, type "I would like to make a comment," and send it to all panelists. No requests have been submitted. Would you like me to close the Q&A feature?
Yes, please.
Thank you.
Okay, moving on, we're going to agenda item 15D14, Wiener healthcare coverage, timely access to care.
Yes. One moment. Okay, SB 221, healthcare coverage, timely access to care. This bill codifies existing timely access to care standards for health plans and health insurers, applies these requirements to Medi-Cal managed care plans, and adds a standard for non-urgent follow-up appointments for non-physician mental health care or substance use disorder providers within 10 days of the prior appointment. This bill passed out of the Senate Appropriations Committee yesterday. Staff recommends the board watch SB 221.
Okay. Is there any board discussion as it relates to this? Or any sentiment about the watch recommendation?
Dr. Phillips, this is Dr. Kasuga.
Yes.
Yeah, I recommended that we watch this previously during our meeting, and I was just like to ask staff about bills that we usually watch, and seems like most of the bills that we watch relate mostly to the ones that affect board processes, and it's kind of like similar to the AB 32 bill. I'm hoping that we can look into bills where there's an access to psychological services issue, or like things that we can possibly support if we can analyze that it would expand access to psychological services. Because I think that part of consumer protection is not only looking at potential harm coming from our providers, our licensees, but also tackling access issues with regards to receiving psychological services due to limitations from existing law. So if there are bills that improves access to psychological services, I think that we should look into those, including this bill.
Any other board comments? Thank you for your comment, Dr. Kasuga. Is there public comment on this?
This is the moderator. I've opened up the Q&A. Members of the public, if you would like to participate, click on the Q&A icon, type "I would like to make a comment," and send it to all panelists. No requests have been submitted. Would you like me to close the Q&A feature?
If you would, please.
Thank you.
Okay. Item 15E is legislative items for future meeting. The board may discuss other items of legislation in sufficient detail to determine whether such items should be on a future board meeting agenda and or whether to hold a special meeting of the board to discuss such items. But we can't actually discuss the substance of the items. So with that in mind, do any board members have anything they would like to have us add as legislative items for future meetings? I always forget to toggle over and see if anybody's got their hand up. No, I'm not seeing any hands up. Seeing none, why don't we open up for public comment for legislative items for future meetings?
Thank you. This is the moderator. I've opened up the Q&A. Members of the public, if you would like to participate, click on the Q&A icon located at the bottom right corner of your WebEx screen and type "I would like to make a comment," and send it to all panelists. The instructions are on the screen for your reference. No requests have been submitted. Would you like me to close the Q&A feature?
Yes, please.
Thank you.
Okay, let's move to agenda item number 16, if that's okay, Mr. Fu. I'm rolling now. Regulatory update, review, and consideration of additional changes. I don't know that there's been a lot of change here, but I know that there were some things you wanted to bring to our attention, Ms. Rivera, if you would, please.
Thank you. And I am actually going to pitch it over to Mr. Glassbeagle.
Oh, I'm sorry.
It's okay.
Good afternoon, board members. Thank you, Dr. Phillips. I wanted to just point out a couple quick updates. The telepsychology package is being reviewed by agency. That means the review has gone all the way through the Department of Consumer Affairs. It's over in agency for their review, and once we get their sign off on it, we are able to submit the final package to the Office of Administrative Law. The other next farthest along package would be the continuing professional development package. We are working on the final statement of reasons. So we had a first draft completed, submitted to legal. It was reviewed and sent back with edits and comments. So we are working on incorporating the edits and comments. After that, I am frequently working on the rest of the packages, including the retired regulations, psychological assistant, and now going to be the fee package, which is just going to get started, but that will become our priority. I am available for any questions should any arise. Thank you, and that concludes the report.
Any board member questions or comments? Okay, seeing none. Oh, Dr. Kasuga, I see your hands up. Is that from the past item or is that for this item? Oh, hand went down.
That was from previous, sorry.
Okay, thank you. Why don't we open it up for public comments?
This is the moderator. The Q&A is now open. Members of the public, if you would like to participate, click the Q&A icon, type I would like to make a comment, and send it to all panelists. No requests have been submitted. Would you like me to close the Q&A feature?
If you would, please.
Thank you.
And that concludes everything for the Legislative and Regulatory Committee, or Legislative and Regulatory Affairs Committee. Thank you for your patience. Mr. Fu.
Thank you, Dr. Phillips. So we will now take up item number 17, recommendations for agenda items for future board meetings. Board members, do you have items for future board meetings that that you would like to be included or potentially included? Dr. Kusuga.
Thank you, Mr. Fu. I'm wondering if we can tackle some, maybe with either the telehealth committee or the enforcement committee, some of the issues related to telehealth with regards to teletherapy and teleassessment that has come up during COVID. I've just been, receiving some questions from other colleagues and other licensees with regards appropriateness of certain modalities, such as, teleassessments performed in like via phone, like audio only appointments and diagnosing, things like that with regards teleassessments, considerations for high-risk clients and teleassessments. And I'm wondering if we can either have that looked into by the telehealth committee, or maybe have like discussion with stakeholders with regards to issues that have come up for telehealth.
Thank you, Dr. Kusuga. I'm actually going to turn this over to Dr. Phillips, who's chair of our telepsychology, ad hoc committee. Dr. Phillips, can you inform us if this item is on the radar of the committee, and if not, would you consider putting this on the future agenda for the committee?
It's not on the agenda. At some point, this becomes standard of practice questions, which generally the board attempts to stay away from in order to allow the field to develop. So I think it's really going to standard of care. and what's appropriate under the circumstances. So I'm not sure if we would be the right repository for that particular question. But I will, Dr. Kasuga, I will speak to Ms. Zork about it, and we'll try to make a determination if that would be an appropriate topic for the telepsychology committee to tackle. And I will get back to you with an answer, and we can bring it up at a future board meeting if you're not satisfied with the resolution of that.
Most certainly, I recognize the concern when we're like looking into standard of care versus like our mandate for consumer protection. The reason why I was bringing it up is mostly because most of there's a lot of services performed, psychological services performed during the past year has been in telehealth. And
Right.
I'm just like really worried that like about potential harm that this newer modality of providing psychological services that is being widely practiced in our state, if there is potential harm that we won't be able to address until way later. And I understand that sometimes that's the constraint of our of what we do is like we may be delayed with regards like we're reliant on complaints, and I'm just like thinking more proactively, but I certainly would appreciate a conversation around it with Ms. Zorek.
Okay, great. Thank you.
Thank you, Dr. Phillip and Dr. Kasuga, for that back and forth discussion. And perhaps we can also, as Ms. Monterrubio provides us these regular updates around enforcement, if that is a pattern of behavior or issue that comes up on that side, she can also share that back with us and include it in a future report if there's something there on that front. So we can have a go at it that way too, in terms of just tracking this issue. So thank you for bringing this up, Dr. Kasuga. I think one thing I would just ask is a more question for Ms. Zorek. Ms. Zorek, I think we've in the past talked about the healthcare professionals fund and a certain amount of the dollars that go towards that fund from psychologist registration fees. And so I think it might warrant a update this year as well. So I leave it to board staff to decide when, given the agenda, how busy an agenda might be for August and November, and when's the appropriate time. But it might be nice to have the fund come back to report back to the board.
Absolutely.
Any further items from the board before we turn to public comment? All right, we'll go to public comment on this front.
This is the moderator. I've opened up the Q&A. Members of the public, if you would like to participate, click on the Q&A icon, type I would like to make a comment, and send it to all panelists. No requests have been submitted. Would you like me to close the Q&A feature?
Yes, please, Madam Moderator. Thank you.
Thank you.
We've already discussed this for item 17, but just the issue that came up during public comment, the licensure committee will go ahead and take a look at this issue in July, and then based on what the licensure committee discusses, we'll bring it back to the board as well. So thank you, Dr. Harpsheets, for at the time volunteering to bring it to your committee so a thorough discussion can be had there.
You're welcome.
All right. Dr. Kasuga, I see your hand up, and I just want to confirm that you don't have additional items.
I always forget to put it down. Sorry.
No, it's all good. I just want to make sure we get back to you. All right, so that is the conclusion of today's open meeting for the Board of Psychology. The board will meet in closed session pursuant to Government Code Section 11126, Subdivision C3, to discuss disciplinary matters, including proposed decisions, stipulations, petitions for reinstatement or modification of penalty petitions for reconsiderations and remands. When the board does come back or comes out of this closed session, we will adjourn for the rest of the day, and we've completed all of our items already. So for public attendees who are wondering when we come back and what items will be taken up, when we do come back, it will be as a formality to adjourn our session today. So with that, I'm going to ask that our facilitators at Solid, whom we owe our thanks as always for these great meetings, to go ahead and secure the room for closed session. Ms. Stephanie Chung will remain here with us as our appointed staff person.
This is the moderator.